it is giving a way, or it is paving the way, or it is giving or recognizing through legally, that is for digital signatures. Whichever electronic contracts are made through a secure electronic channels are legally valid. This act is capable of any offence or contravention committed outside India, as well as the electronic transfer of funds between the banks and the financial institutions. Hi and a warm welcome to you all dear students. I, George Elme, Commerce Faculty, Department of Commerce, Vidhyaashram First Grade College, the Temple of Excellence, MYSURU. Dear students, today we shall take up the session 1 for Unit 5, that is Information Technology Act 2000 of your business laws. Now let us understand what is this Information Technology Act 2000 in the introduction part. So here in 1996, it says in 1996, the United Nations Commission on International Trade Law, that is the short form UNCITRAL. So U stands for United, N stands for Nation, C stands for Commission, International, T stands for International, then A stands for Trade Law, right? So this adopted the model law on electronic commerce, that is e-commerce. So in 1996, the United Nations Commission on International Trade Law, that is UNITRAL, adopted a model law that is on electronic commerce, that is e-commerce, in order to bring uniformity in the law in different countries. So in order to bring the same common practice or the uniformity in the laws which has been practiced in different countries, this act called as UNITRAL Trade Law, that is Commission on International Trade Law, was adopted by United Nations in 1996. Now further, if you see, the General Assembly of the United Nations, right, recommended that all the countries must consider. So the General Assembly of United Nations, it recommended the countries that all the countries must consider this model, that is the UNITRAL model, before making changes in their own laws. So they said that before making, if you want to make any changes in your own law, then they said that they recommended that all the countries must consider this particular model, that is adopting the international trade law, before making any kind of changes in their own laws of their country. Now India became, coming to our country, India became the 12th country. India became the 12th country in order to establish this cyber law. So information technology means we call it as a cyber law. It was passed, the Information Technology Act in 2000. So our country, India, was the 12th country which enabled the cyber law, that is after passed the act in the parliament, and that is passing the Information Technology Act in 2000. Now while the first draft was created by the Ministry of Commerce, so the first draft, before the act could be amended, the first draft, it was created by the Ministry of Commerce and Government of India as E-Commerce Act 1998. So in the year 1998, so the first draft was created by the Ministry of Commerce, that is Government of India, as E-Commerce Act, and it was again redrafted as an Information Technology Bill in 1999, and later on it was passed in the May 2000 as Information Technology Act 2000. So the first draft was created by Ministry of Commerce and that is Government of India as E-Commerce Act 1998, in the year 1998. Then later it was redrafted in the year 1999 as Information Technology Bill, and later that particular bill, Information Technology Bill, which was redraft 1999, was enacted as a law or amended as a law and passed in the year May 2000 as Information Technology Act 2000. Now what are coming to the objectives of law, or we say coming to the objectives of act. This Information Technology Act 2000 provides a legal recognition. Why this particular, or what is the intention of this particular Information Technology Act 2000? This Information Technology Act 2000, it is providing the legal recognition. Means legally it was recognizing what? the transaction done via electronic exchange of data. So if you are doing any transaction that is in the mode of digital mode or through electronic means, so for those kind of transaction, this particular act called as Information Technology Act 2000 was giving the legal or what you call the recognition, and also other electronic means of communication, right? Not only the electronic exchange of data, but also any other electronic means or communication or electronic commerce transactions. For all this, it gave, the Information Technology Act gave a legal recognition. Now this will involve the use of alternatives to the paper-based method. So earlier we were using the paper-based method in order to recognize this kind of or giving a legal provisions or the permission for doing the transactions. But now this was changed. So here this particular act involves the use of alternative, that is giving there are different prospects where from the paper-based method of communication and information storage to facilitate the electronic filing of documents with government agencies. So earlier they were having documents and they were filing that particular, all the transactions they were doing it in paper or through paper mode, and they were storing them in the form of a ledgers or in the form of a files, everything. Now that is been converted, that particular storage of data, storage of the files and all the details relating to the transactions of e-commerce was stored, and it facilitated the electronic filing of documents, that is with the government agencies. Now further, if you see, this act amended in the Indian Penal Code 1860. So in 1860 this act was amended according to Indian Penal Code, and the Indian Evidence Act 1872, the Bankers Book Evidence Act 1891, and the Reserve Bank of India Act 1934. And the objectives of these acts are as follows. So this act, that is the Information Technology Act 2000, it amended the Indian Penal Code Act of 1860, the Indian Evidence Act of 1872, the Bankers Act Book Evidence Act of 1891, the Reserve Bank Act of 1934. And there are some objectives of this particular act, that is of Indian, that is Information Technology Act 2000. It says, first, grant legal recognition to all the transactions which is done through or via electronic mode or exchange of data or any other electronic means of communication, or it can also be like e-commerce in the place of earlier paper-based method of communication. So first and foremost objective of this Information Technology Act of 2000 says granting of legal recognition, that is to all the transactions which is done via through electronic means or through electronic mode or electronic exchange of data or any other electronic means of communications or of e-commerce. That is in place earlier, in place of the paper method or paper-based method of communication, now it is been digitally, everything is been accepted through electronic means through e-commerce. Secondly, it gives legal recognition to the digital signatures. So earlier we used to sign, take a pen and sign for that particular document. Now this particular Information Technology Act 2000, it is giving a way, or it is paving the way, or it is giving or recognizing through legally, that is for digital signatures for the authentication of any kind of information or of matters requiring legal authentication. Now for example, if there is a fax message which is sent by the CM or the DC to any of the colleges or any of the institutions, so they are not going to sign in that. So it is the digital signature will be there, and that has been authenticated and that has been proved as a legally it has been valid. So that is what it says. So giving recognition to digital signatures for the authentication, right, for any of the information or the matters which is related or requiring legal authentication or legal signature. Then third important objective says facilitate the electronic filing of documents. So it will surely facilitate the electronic file of documents instead of paper-based documents or the files which we were keeping earlier. So now this can easily, we can see that it will give a way, or it will facilitate the electronic filing of documents with government agencies and also the various government departments. And surely it says the next objective of this particular act, Information Technology Act 2000, it facilitates the electronic storage of data. Through electronic system or through digital, we can store the data where earlier we used to have the manual in files and books and ledgers. The next objective says it gives legal sanctions and also facilitates the electronic transfer of funds between banks and financial institutions. So this particular Information Technology Act 2000, it is giving a legal sanction. It gives a legal sanction for the banks and the financial institutions so that they can transfer their funds via through electronic mode. So that permission or that particular legal sanction was permitted, and it is permitting the banks as well as the financial institution for transferring of funds through electronic means. So nowadays we can see the NEFT, then RTGS like this, where you electronically you can transfer the funds from one bank to another bank, from one account to another account like this. Then grant legal recognition to bankers under the Evidence Act 1981 and the Reserve Bank Act of 1934 for keeping the books of accounts in electronic form. So even this Information Technology Act 2000, this is giving the legal recognition, granting the legal recognition for all the bankers, that is, which is coming under the Evidence Act of 1891 and Reserve Bank Act of 1934, where they are allowed to keep the documents, that is in the form of or they keep the accounts in the form of electronic mode or in electronic form. So those were the objectives, students. Now coming to the features of Information Technology Act 2000. What are the features? The first feature says all electronic contracts, whichever electronic contracts are made through a secure electronic channels are legally valid. So if any contracts are made through electronically or through via digital, that has been valid according to Information Technology Act. Then legal recognition of a digital signature. It is not required that when you do the contracts, when you do it through the electronic mode, there is no necessity of you signing it personally. So that particular document will be signed and authenticated, and it is been given the legal recognition, that is through the Information Technology Act. So legal recognition for digital signature. So we call that particular signature as a digital signature. Then security measures for electronic records and digital signatures are in place. So whatever the signatures which you are doing, right, on whatever the records which is been recorded through electronic mode, so that kind of transactions, those kind of what you call the records, it will be having a safety measures, and that also, and even the digital signatures are also having a safety measure so that no one can manipulate it. Then a procedure for appointment of adjudicating officers for holding inquiries under the Act is finalized. So you can have, there is a procedure. So if there is any kind of things happen, if there is any kind of what you call misappropriation of funds or any kind of the signatures is been or documents is been faked. So in this case, there is a procedure for appointment of the officers adjusting what you call the adjudicating officers for holding inquiries into that particular matters, which is coming under this act is finalized. Then provision for establishing the cyber regulatory. Then appellant tribunal under the act. Further, this tribunal will handle all the appeals which is made against the order of the controller or adjudicating officer. Then also it says the next feature says an appeal against the order of the cyber appellant tribunal is possible only in the High Court. So if any appeal has to be made against the order of the cyber law or the cyber appellant tribunal, it is only where you can go and appeal in the High Court. Then digital signatures will use as an astrometric crypto system and also a hash function. Then provision for the appointment of the controller for certifying authorities, that is in order to get the license and to regulate the working of certifying authorities. And the controller who is doing this particular act are a repository of all digital signatures. So in that it says the act applies to offences or contraventions committed outside India. Then the senior police officers and other officers can enter into any public place and search and arrest without any kind of warrant under this particular act. Then provisions for the constitution of a cyber regulation advisory committee in order to advise the central government and controller. So there is a provision for constituting a cyber regulation advisory committee, so that this committee will be recommending as well as advising the central government and the controller regarding the various policies and the rules and regulations. Now coming to the applicability and non-applicability of this act. where it is applicability according to section 1 of 2 of the act extends to the entire country. So this Information Technology Act is applicable to entire country of India, which also includes Jammu and Kashmir also. In some of the cases, Jammu and Kashmir was left over where it was not applicable. But this Information Technology Act 2000, which has been passed or enacted in Parliament, it is applicable to all of India, including Jammu and Kashmir. In order to include Jammu and Kashmir, the Act uses Article 253. So in order to include Jammu Kashmir for this particular Information Technology Act, so it is using Article of 253 of Constitution. And you see further, if you see, it does not take citizenship into account and provides extraterritorial jurisdiction. Now section 1(2) along with the section 75 specifies that it is that this act is capable of any offence or contravention committed outside India as well as. Then if the conduct of a person constituting the offence, if any person is involved and is being made as offence, then involves a computer or computerized system or network located in India, then irrespective of his or her nationality, the person is punishable under the act. So if any person through his conduct constituting an offence, that is, he makes a mistake or commits a crime, right, and involves a computer or a computerized system or a network, which is located in India and using all these electronic modes, then whatever may be the case of citizenship, irrespective of his or her citizenship or nationality, that person will be punishable under this particular act. Then lack of international cooperation is the only limitation for this provision. So here the lack of international cooperation is only the advantage or demerits of this particular provision. Coming to non-applicability, where it is not applicable, it says according to section 1(4) of the Information Technology Act 2000, the act is not applicable to the following documents, such as execution of negotiable instrument under Negotiable Instrument Act 1881 except checks. Secondly, execution of the powers of attorney under the Powers of Attorney Act 1882. Then creation of trust under the Indian Trust Act of 1882. Then fourth, it says execution of the will under the Indian Succession Act 1925, including any other testimony deposition by whatever name is called. Then entering into a contract for a sale of conveyance of immovable property or any other interest in such property. Then any such class of documents or transactions as may be notified by the central government in the Gazette. So these are the important Information Technology Act 2000 where it is not applicable, in which areas. Now students, let us go back and just see what all we have understood in this particular session. This Information Technology Act was like in 1996, the United Nations Commission of International Trade Law adopted the model of electronic commerce, that is e-commerce, to bring the uniformity in the law in different countries. Then further it says General Assembly of the United Nations recommended that all the countries must consider this model before they make any changes in their own laws. And India became the 12th country to enable the cyber law, that is after passing the Information Technology Act in 2000. While the first draft was created by the Ministry of Commerce, that is Government of India, as E-Commerce Act in 98, then it was redrafted as Information Technology Act or Bill, Information Technology Bill, not Act, in 1999. Later, it was passed in May 2000 as Information Technology Act of 2000. Now, this Information Technology Act 2000 provides legal recognition to the transaction which is done through electronic exchange of data and all related other means of communication or electronic commerce transaction. And this particular act involves the use of alternatives, that is to the paper-based method of communication and information storage to facilitate the electronic filing of documents with the government agencies. And further, if you see, this particular act amended the Indian Penal Code 1860, the Indian Evidence Act 1872, and the Bankers Books Evidence Act 1891, and the Reserve Bank Act of 1934. And what are the objectives of this? It says it grants legal recognition to all the transactions which is done through via electronic exchange of data or any other electronic means of communication, that is or e-commerce in place of earlier paper-based method of communication. Secondly, it gives legal recognition to digital signatures for authentication of any information or matters which is requiring the legal authentication. Thirdly, it facilitates electronic filing of documents with the government agencies and also the departments. And fourthly, it facilitates electronic storage of data. Then fifth objective says it gives legal sanction, also finance or facilitates the electronic transfer of funds between the banks and the financial institutions. Then granting or grant of legal recognition to bankers under the Evidence Act of 1891 and the Reserve Bank Act of 1934, that is in keeping the books of accounts in the electronic form. Coming to the features, all electronic contracts are made to secure electronic channels are legally valid. Secondly, legal recognition of digital signatures. Third, signature, that is security measures for electronic records and also digital signatures are in place. Fourth, the procedure for the appointment of adjudicating officers for holding inquiries under the Act is finalized. Fifth is provision for establishing a cyber regulatory, then appellate tribunal under the Act. Further, this tribunal will handle all the appeals made against the order of the court of the controller, order of the control of adjudicating officer. Then an appeal against which is made in the order of the cyber appellate tribunal is possible only in the High Court. Then the digital signature which will be used as asymmetric crypto system and also as a hash function. Then provisions for the appointment of the control of certifying authorities in order to license and to regulate the working of certifying authorities. And the controller to act as a repository to all the digital signatures. And this act implies to all offences or contraventions committed outside India. Then the senior police officers and other officers, they can enter any public place and search and arrest without any kind of arrest warrants. Then the provision for the constitution of the Cyber Regulation Advisory Committee to advise the central government as well as other controllers. Applicability, it says it extends to entire India country, which includes Jammu Kashmir, and to include Jammu Kashmir, it uses the Act of Article 253, that is under Constitution, and it says that it does not take any kind of citizenship in account and provides extraterritorial jurisdiction. Then also it says Section 75 specifies that the Act is applicable to any offence or contravention committed outside India as well. If a convicted person constituting the offence involves a computer or computer systems or network located in India, then surely, irrespective of his or her nationality or any country he belongs to or citizenship of any country, the person is punishable under the Act. And lack of international cooperation is the only limitation for this provision. Non-applicability, it says execution of negotiable instrument under Negotiable Instrument Act of 1881 except checks, execution of a power of attorney under the Powers of Attorney Act 1882, creation of the trust under the Indian Trust Act of 1882, execution of a will under the Indian Succession Act of 1925, including any other testamentary deposition by whatever name called, then entering into a contract for the sale of conveyance of immovable property or any other interest in such property, any such class of documents or transactions are as may be notified by the central government in the Gazette. So students, these are the various important topics related to this particular Information Technology Act. We shall continue. Still, there are some more other topics also which are related to this particular Information Technology Act of 2000. So hope you understood the session. So it is only totally, it is of all about the Act and the bills and the laws. So only if you read it, you will be able to understand. So see you in the next class, students. Until then, take care. Have a nice day. Thank you.